Well, the trial of 5 men accused of murdering soccer star Senzo Meyiwa has adjourned for a brief moment, as it's expected to continue in the Gauteng High Court in Pretoria later today. But let's get some analysis now on the Senzo Meyiwa Murder Trial, and for that we're joined by Advocate Romeo Nthambeleni, who is a senior legal analyst and member of the South African Bar Association. Advocate, a very good morning to you. Thank you so much for joining us. I think as the week kicked off, as you looked into this trial, the issue of accused number 5 bringing the application, his representative bringing that application, saying that he has been denied a fair trial, has gotten a lot of attention. Do you agree with Advocate Mshololo and the argument that she's putting on the table?
All right. Thank you, and to you and the viewers. I think yes. If it can be proved that the information that she is alleging that was not given, indeed, I will definitely agree with her. But the question is it the right moment to actually bring that application? Because normally you bring that application at the end of the trial when the court has already, finalized everything, and you are preparing, for appeal. That when the record goes to appeal, that will be part of the record. I think that is, of critical importance. The moment and the timing of that 317 application that you are actually referring to, that deals specifically with a special entry. And then now that's my take on the issue.
It does place her in between a rock and a hard place, right? Where you talk about how the timing of it, usually this sort of application would be made towards the process of an appeal. But we do know about the second docket in this case, docket 375. So in this sort of case where we do know that there is a second document, what then is the procedure at this stage?
Yeah, look, this trial from the onset has been riddled with irregularities. Insofar as those 2 dockets are concerned, I think they should have been conflated and then become one docket, and it was going to make the case much more easier to actually handle. And then now that there are 2, and then previously you remember we have heard that the NPA indicated that they don't intend to actually pursue that other docket, and then they are now making a 190-degree turn and saying that they want to pursue that docket, and they want to conduct a separate trial. And yesterday, before the commencement of the proceedings, it was the issue of the debate, the relevance of that 375 docket that you're actually speaking about, and its relevance to the current trial. And Advocate Mshololo indicated rightfully that this is the case on the same facts, on the same merits, and then it does really have an impact, and she's going to indicate the court as to how it is having the impact when she addresses the 317 application that was before court. And that is when she introduced this, and there were issues relating to the statements that were given by Sergeant Musia and Sergeant Love that were contradictory to the statements that were before court on the same case. It creates a lot of problems, and how was the docket not conflated into one? I don't know. I think NPA can answer for themselves as to why the situation we are finding ourselves in this situation.
Yeah, but what then are the opportunities for the trial to continue without the exclusion of that second docket 375, right? Is it possible to hold parallel court proceedings?
This is a little bit unprecedented. We've never had a situation like this where in one matter you have 2 dockets. Hence, I'm making emphasis to indicate that it is better if you conflate these dockets and make them one. That way you will be able to handle a proper trial. And then if you separate the trial with 2 different accused, because there was also an indication yesterday that there will be witnesses that will be on the other 375 docket that will come and testify before court. So it really creates an untenable situation, and this has never happened before.
But what is the likelihood then of us seeing that second docket included into this trial, and what you were saying or proposing as the better way of handling it, instead of having 2 separate matters looked at separately?
Mm-hmm. Yeah, apparently, yeah, absolutely. The NPA should have done that a long time ago. But now, with the letters that were coming, it is clear that the NPA seeks to conduct a different trial on altogether, we're on the 375, and then hence you had arguments that were being brought by Advocate Msholo rightfully saying that we cannot divorce the 375 from the current proceedings because of the issues that we are raising, the statement that were issued, and then them being contradictory in nature on the same case, on the same facts. And the judge said she must bring the application, and then the judge is going to entertain that application to see how the 375 docket is actually relevant to the proceedings that are before court.
Yeah, I want to look at the issue of the 5 accused for a moment, Advocate, and say, well, considering that you've got the second docket and now there's back and forth around whether or not that docket is included into the court proceedings as they unfold, what do you think this means for the 5 accused? And I'm talking about the possibility of us seeing a conviction here, and if somehow the state's case is now so badly tainted that a conviction becomes quite difficult.
Yeah, absolutely. Yeah, you're correct. Because that is precisely what Advocate Msholo was arguing yesterday relating to the plea, to say had she had the information earlier, perhaps the plea could be different. And then that really impact on how the case will actually pan out at the end. So that is very, very much important to actually say that you might find that at the end of the trial there's an acquittal because the state has to prove their case beyond reasonable doubt. And what is being created here is doubt already, because there are already 2 different dockets in the very same matter with the different accused persons that are supposed to be brought before court. So the standard of the test in criminal cases is beyond reasonable doubt. And then if you create doubt, you are really showing the court that there is doubt that the people that are brought before court are not the people that have actually committed the murder. And if you can pass that standard, then definitely you are going for an acquittal. And that is where we might be heading.
At the heart of the matter, Advocate, is the Meyiwa family that has been looking for justice for many, many years. And I mention this a lot because that's what South Africans really are wanting to see as we watch this trial. And we've seen delay after delay. Aside from this issue now of the second docket, yesterday, Sergeant Thabo Mosia, not well, unable to take the stand. I mean, looking at the process that is still coming before us, how much more delays do you think we're going to be seeing moving forward?
Yeah, no. With this trial, we can't guarantee. We can't really put the time frames as to how the proceedings will actually unfold, because we can see, as you are rightfully saying, that there are more delays, in terms of how the trial is being handled. And let's hope that after the hearing of this application of 317, then the cross-examination of Sergeant Mosia will continue, and then the matter will proceed, so that at least we can see justice in the end of the day. Because in law we say that justice is delayed, which is delayed is justice denied at the end of the day.
Yeah. Before I let you go, I think what this trial certainly has taught us is to really look very closely at what our authorities and law enforcement really does with trials such as these, and also how the justice system manages very complex matters. I mean, looking at the work of the National Prosecuting Authority, the appearance of the second docket, and now things unfolding within the courtroom, all the way from Malesela Tefo and him leaving the process as well. What does this say to South Africans, and perhaps to yourself, about the quality of law enforcement in the country and the quality of the justice system in the country?
No, we are not perfect. A lot can improve. It doesn't only happen in the South African criminal justice system. All over the world, it shows that there might be cracks in the system that really need to be attended to. But it's not something that should deface us as South Africans. We should have still hope in the criminal justice system that if things are done properly, at the end of the day, justice is going to be done. So that is very much important.
Yeah, we thank you so much for your time. That there was Advocate Romeo Nthambeleni, who is a senior legal analyst and member of the South African Bar Association, giving us some analysis on the Senzo Meyiwa murder trial.